Campbell will be representing Justin Baxter as we approach the court with a request of reversal in regards to his prior judgment under Criminal Code Section 3918-504. On the evening in question, Mr. Baxter, a law student, chose to attend a classmate's party where there was alcohol involved. When it was time for him to leave, him and his classmate both decided that it would be most appropriate for him to ride her bike home in order to avoid receiving a DUI. Now, we are not questioning whether Mr. Baxter chose to ride a bike while under the influence, but rather whether a bike fits into the legal definition of a vehicle. Mr. Baxter demonstrates no desire to break the law, and it is proven not only through his testimony, but also through the eyewitnesses. Also, due to the clear language used in the statute, a bike fails to qualify as a vehicle, and when using the Holden v. State case as a guiding principle, a bike seems very unlikely to be regarded as a vehicle in cases such as these. Mr. Baxter shows a clear understanding of the law when he decides to have a conversation with his classmate about the means of getting home. Mr. Baxter chose to ride a bike in order to avoid receiving a DUI, but also to avoid driving while under the influence, recognizing that you do not drive a bike, but instead you ride a bike. When looking at the definition of vehicle under the Criminal Code, we find that it says any appliance including automobiles, streetcars, or wagons pulled by beast of burden that transports people from one place to another. And while a bike fits into the definition of transporting people from one place to another, it fails to meet the standards of being pulled by beast of burden, seeing as its momentum is initiated and powered by the human being in act. We also acknowledge the Holden v. State case, where the defendant chose to partake in kayaking while under the influence of marijuana. In this case, the court found Holden innocent under effect of the clear statutory language of Section 3918-504. They found the trial court erred in finding Holden guilty of operating a vehicle under the influence. Recognizing that a bike and a kayak both do not travel at high speeds like a car or have the power of a horse-drawn wagon, and both of those vehicles have the capacity to cause serious bodily harm or even death to others. When comparing the two cases, we find the similarities being that while a bike and a kayak do have forward momentum, it is all initiated by the human being's force, whereas a car or an automobile or a wagon is powered by some inner working force. In this case, the prosecutor might move to say that under civil definition, a bike would qualify as a vehicle due to the phrase machine, and that since the defendant is studying the law, he should have a clear understanding of the statute and its implications, which he does, seeing as vehicle does not include bicycle. Also, there could be a movement that the case is completely different from Holden, seeing as the means of transportation are different. But when taking into regards the similarities of the necessities that both of these individual items need in order to be powered, we find that they are more alike than different. In conclusion, due to the clear definition of vehicle in cases prior but similar to this one, the defendant Justin Baxter should not be found guilty moving forward with the belief that the trial court was erred in finding Mr. Baxter guilty, therefore the prior judgment be reversed. Also, we move to have the rule adopted that a vehicle by legal definition within the confines of Criminal Code Section 3918-504 is a machine and or an appliance that's momentum is dependent on the initiation of a human, but its overall source of power is not provided by the person in question. That also requires certain licensing due to their capacity to cause seriously bodily harm that can result in death. Using the examples stated by the criminal code, automobiles, streetcars, or wagons pulled by beasts of burdens.